on intellectual property in today's business landscape. So here I would like to invite our moderator, Muna Farid, Director of Hatch Consulting, FZE UAE. Joining here an unexceptional panel of experts around the globe, each bringing a unique perspective to the table. So here I welcome our panelist, James M. Hall, CEO and founder, Global GC. Okay, so maybe he's a bit running late. And the next one is Sanjar Muminov, President Sandhar Group UAE. And third is Mohammed Hegazi, Senior Consultant for Regulatory and Compliance Affairs, Digital Economic and Technology General Division, Egypt. Syed Mushir Ali, General Manager, United Trademark and Patent Services. I welcome you all.
Mr. Mubashir, you have to join the stage. Please, why don't we just get closer because I think one or two people are not. So.
Thank you, everyone.
Thank you. So I think there are a few of us, so I think this is a great opportunity for everyone to jump in and be part of the conversation. I think that'll be much more productive, hopefully, for everyone. So I'll do a very brief introduction, and then I'll let each of the panelists introduce themselves. And then I think it's just going to be short presentations by each of us, certain topics, and then we're going to have a conversation. So my name's Muna Farid. I'm, of course, a lawyer first, but now a consultant. I've worked in a combination of financial services, FMCG, as well as healthcare industries. I now work around technology, as well as general commercial market access, as well as investment advisory. So I'm really delighted to be here. I always really enjoy this event, and I'll be moderating today. And actually, just speaking to our friends here, we have a lot of experience on the stage. So I think without further ado, we're going to start there. I'm just going to speak very briefly on IP and generative AI, because I think that is the hot topic of the day, and it's quite important for businesses either using Gen AI or intending to use Gen AI to really understand what they're getting into. And I've got a very simple sort of top 10 list of things to, I think about before we get into this area. So without too much ado, I think I'm just going to go into the list and talk a little bit about how I think at this point, mostly from the litigation landscape as well as from an information perspective, it's a very early time. Judges, we're going to be relying heavily on judges to make decisions in multiple jurisdictions. These nuances in Gen AI in particular require very deep understanding of technology. The big tech have been very smart. There are very few players in this game who actually will be really running this space, just because of the large amount of investment you need in order to actually be a Gen AI player. So at the end of the day, it's going to be a few, but impacting pretty much every single one of us in one form or the other. So I think as lawyers, and as IP lawyers in particular, it's going to be extremely important to understand how it impacts your business, how it impacts you as an individual, whether it's your data that's being trained, or whether you want to own something, whether the whole value of your business is your IP asset, which is somehow related to the Gen AI space. So I think it's extremely important to, I think no one will have a grip on it at this point in time, but certainly everyone in this room, and particularly the next room, should be paying attention to this space. So essentially, I would say that if you're a new user, or your firm is a new user, it's going to be extremely important. And any client of yours, I think the first piece of advice should be, please inform your staff that if they're going to engage with ChatGPT or any form of Gen AI, they're going to generate something using it, they're going to create something, or they're simply researching or experimenting, any touch point, there has to be a clear guidance to the teams that the information you put in there is not confidential. So no one should be actually working with confidential information on those open systems, regardless of what use or regardless of the outcome that you're actually trying to. So the easiest, best thing to do is frame a nice informational email to the staff, get everybody on board with do's and don'ts, because you're not going to be able to police everybody, and frankly, it is the future and the future is here, so you would want your staff in some form or the other in the right way to be using these technologies. So first and most important is confidential information loses its confidentiality the minute you put in anything, a prompt or any information that you're uploading to the system. It's extremely important. The second, for all of us, I think from a commercial perspective, from a business perspective, to protect our clients, is you really need to understand what are the IP implications, which part of the IP law is actually getting implicated, or do you have protection, don't you have protection, is there any coverage at all with respect to your local jurisdiction or your international jurisdiction for the product or the service that your client's actually trying to provide around Gen AI. It's extremely important because copyright seems to be the most obvious, but there could be, if copyright's not available to protect your client in that particular instance, it could be maybe you have to look beyond that. You have to look at trade secrets, you have to look at contractual language, you have to pretty much go across the spectrum that might allow you in some form to actually protect your client's interests, if it's applicable, and that's the biggest question. So if ownership is important, if you're representing a software company, and the source code, for example, is extremely important that they own it outright, it's highly recommended at this point that you discourage your staff and anyone on your teams to actually use any of these generative AI tools to actually create that software or write any part of that code. Because different companies that you're engaging with, for example, I think Microsoft actually assigns the rights to whatever data that you're putting in or whatever outputs that you create using their tools, I think back to you. However, there are other companies whose tools, if you use, they get assigned into the public domain. So if you care and you need to protect, and that's an asset, and that's your whole business, for sure, you should not be using any of the generative AI tools for your business. Then, most importantly, guide your clients. There are more people in litigation right now just because they inadvertently claim that they have a copyright in something that they created by using these models. It's extremely important that you dig deep into all the touch points, all the data, for example, if models are being used, all the outputs that are coming out to make sure that your client is not misunderstanding that they somehow have ownership rights with respect to the outputs, if that's not the case. So it's extremely important that they don't falsely claim they have a right to something, or most importantly, don't misunderstand that they have a right to something, which they in fact don't. The other really important point is you have to understand the infringement risks as well. If someone else is going to infringe on your product or your service, well, you need to understand where your rights are and how you're going to protect them. So that's another very important assessment that you need to do for your clients. In terms of service, how many of us actually say yes blindly, even as lawyers? When these terms of service pop up and we actually want to get to the outcome of what we want to do. How many people just accept cookies, etc. Pretty much all of us, I'm sure, at one point or the other. It's time now that when Gen AI is involved, those terms of service actually matter. You really do have to get into the fine print and understand that once you're engaging with Gen AI, what are you giving away, what are you getting, what do you own, what you're going to lose, what don't you have the rights to, what do you have the rights to. And if you are on the side who's advising clients to establish these terms of service, you need to do it in reverse and make sure you understand the implications. Most of these are written, in non-accessible language, frankly. They're not in plain English for the most part. So it's even more important now for us as lawyers to understand, or commercial practitioners to understand, what do these terms actually mean? And particularly vis-a-vis big tech, what are we actually agreeing to do? It's It's extremely important, and that language really matters more now than ever. Then what can you do if you are already using it, you're in the space, your client needs to use it for their work purposes? What are you going to do? Well, you can start putting in some language into your websites. You can limit access. You can put in language saying that this belongs to such and such, this is copyrighted. You can put in as many disclaimers as you want. You can also put in some rights to either reverse anybody who's come in and scraped your data. You automatically can notify them, and you have to monitor, obviously, that's also a cost. In addition, you have to make sure that you can regulate the access. So who's accessing, who's coming in, who's scraping, who's using, for what purpose. Those are additional compliance measures. If it matters, if it's relevant for your business, those are really, really important access points and controls and monitoring that you have to put in. Then, so the last two that I have is strategy. If there's a strategy to use Gen AI, if there's a strategy where Gen AI is going to be relevant to your business, then I think still, without fail, the agreements that you sign up to, that your client has with others, terms of use, contractual warranties, whatever it is, your major contractual agreements have to cover a lot of different aspects. And there you have to be a bit careful, because in some jurisdictions there are implications. You try not to box the exact IP law that actually is involved. So for example, if you've got a source code, or you've got something that's less obvious, and you're not sure which area of the law applies, you really have to go a lot broader. You really have to think that, potentially you could fail in a court with respect to the application of one form. But if there's a borderline aspect, if there's a strategic element that you could use, then try to protect as much as possible, as widely as possible in your contracts. And most importantly, you have to put in strong liability and infringement language if those are relevant. Last but not least, if you are an investor or you're advising clients who are investing, you absolutely have to dig deep and understand from a valuation perspective, if there's a Gen AI generated output that you're trying to protect, and that's going to be an asset, you absolutely need to understand how that's going to be valued, and most importantly, the implication of all of these risks. You have to do a proper risk assessment to see, okay, what if there's an infringement? What if this is something that I've misunderstood that I own? What if others have used my product without my permission? How do you protect the client? So risk management versus valuation. And long term, is this thing actually going to be viable? Is it sustainable? Is this a technology that's actually going to last the day before someone puts in millions of dollars into it? Very last, liability. Liability is extremely important. Liability versus reliance. You have to make sure that your clients understand that if their product is something novel, particularly, we're in a very uncertain period in terms of the law, because the laws are antiquated, technology has moved faster than the legislators in most cases. If they find themselves potentially even that there's a remote risk, clients need to understand that. And if they're unduly relying on any particular aspect of the law, they need to also understand that potentially they may or may not be secured in the near or the long term. So those are sort of my points that I think any business needs to think about, either if they're engaging with Gen AI or they plan to use it in some form, or they're commercially involved in some manner. Every single industry and business in some form or the other is using data, is using models. They need to, in order to stay ahead of the business, stay ahead of the curve. They need to do it because everybody needs to, there are efficiencies, there are cost benefits, there's innovation involved by utilizing these particular technologies. So no one can escape it. And at the end of the day, I think that we're best placed as practitioners to understand that there's no straight answer, but we can do things at this point which are available to us to protect the clients as much as possible. That's it.
Thank you. Very nice to meet you here. I'm Dr. Sanjar Mumino. I'm 28 years in the IT. In the last 8 years we are working with the headquarters here, but we're operating in 35 countries all around the world, starting from US up to Korea. You can find information about me in internet. I don't want to waste your time. Just I want to share my experience, our personal experience with the clients in terms of GNI create content and other things. So there are two main IP industries that we can consider. Mostly it's confidential and trade secret that you can mention in your speech. And second, the copyright. As per our experience, patent very difficult to use to protect digital solutions, almost impossible. Because it always connected to some kind of technical devices. Without technical devices, nothing. So now, last 4 years, we are strictly focused on the copyright. What is the main problem with copyright? There are no state monopoly for copyright registration. Till now, there are no one country all around the world have any clear instruction how to compare the creative concept of copyright work. This is a big challenge. And we're trying to do as leaders in UAE, in this industry, for ourselves. We're trying to create some documentation to do. Regarding trademarks, it's perfect. You have any kind of analysis, similar, confusingly similar, with the patterns the same, by verbal, by visual, but for copyright, nothing existing. I think this is a big challenge, and we, as the participants of this market industry, we should do something from our side, just to teach, to educate. With copyright, the copyright, to create the copyright, no permission is required. You create it, that's it. But the problem is, second, is verification. So, last 3 years, we spent a lot of time and efforts to find this main, we created about 20 criteria, 20 criteria, how to verify the copyright. Because only creation is not enough. Creation not give to you enough evidences for the date of creation, for the author, for the right holder, and you know that 99% of your clients that don't know that copyright should be expressed in some evidentiary form that some others confirm. And we know that from 20,000 copyright offices which exist all around the world, only 3 provide verified registration, where they're checking the content, where they're checking the right holder, author, conduct KYC, only 3. From these participants, do you know which 3 copyright offices doing this work? If you, as an expert in this industry, not informed, it's very difficult to talk with the clients. Because to them, only creation is not enough. But even verification of copyrighted work is very important and challenging task, but it's not last task. We are now facing the problem with ChatGPT created the content. Because this content play now very sufficient role in the development of any business. But this content was created by AI, it's not by the human. It's not classified as IP in the old school definitions. So we now, it's our idea, our recommendation, we put the definition of the third step. So number 1 is creation, number 2 verification, number 3 segregation. We start thinking how we can segregate the created content. Where is the input of the human who created this content, and what is the part of the AI generated content. And we understood this our practical experience. Maybe we mistake, but we should do something because government not touching copyright at all. The copyright something existing, pay $10, send by envelope, they don't care. There are no state monopoly, like invention or utility or other things. So which output we have identified. That in the segregation process, the human input is in the request when you send it. And this request, which was created to receive the answer, could be considered as an IP of the company who created this work. So maybe we'll prepare also from our side some instruction or recommendation, because if you create the request, you can check. Usually for the same request, AI-generated tools like ChatGPT or others, they giving mostly similar answers. That's the reason why this result was created based on the effort of the human. And this part on the segregation could be protected. So I'm very shortly putting my ideas. If you have any question in this panel session, we are sharing experience. I'm very happy to answer your question. So just short summary. In the digital industry, patents almost not applicable. Trademarks also registered globally, worldwide. 100 trademarks with extension classes, challenging task. We should go to copyright. For copyright, not existing state monopoly. And for digital assets, even for source code, even for others, we consider copyright as a main tool. Maybe now it's time to give some, at least on the community level, some clear guidelines how to provide copyright registration with verification with segregation process. If we will do it, I think we will assist, at least to our clients, to properly provide protection and then go to the valuation. Also this valuation of the intangible assets should be provided in the accordance with the international standard 210. I don't know if somebody from participants know about this standard, 210 standard valuation of intangible assets. No one. So I try to understand the standard. There are more than 60 methods, 60 methods how to value. So it means this dead standard. I meet with the head of International Valuation Standard Council in UK, in London, with me. I try to how we can make this like workable to the normal people who can understand. Only Big Four maybe can understand this standard. Apart of them, no one understands. That's the reason why they're not using this intangible assets standard. And even here in many countries, not existing proper licensing system of the appraisers who knows all the specific point of intangible asset valuation. This is a very challenging task. That's the reason why it's, you know, you mentioned the valuation. The valuation market right now is wild, absolutely wild. If you want to value a mobile application, just try to give this task to 5 different consultancy companies. The range of valuation will be from 1,000 to 1 billion. It's absolutely wild. Not existing clear understanding how to classify the IP portfolio. What methods should be used for valuation? How to be prove? Who can verify? So I think this is also next area where we as a community we can focus and to do something, some new kind of instruction on the value of IP. Because and now, you know, what is the biggest problem with the last 4 years we are focusing on investment deals. And as per our experience, the biggest money coming when existing something which is not publicly disclosed. Not patent, not copyright was protected inside the company, internally. And here we touching the trade secret. This is a big headache. Government also not participating in trade secret creation, process creation. Government just put the requirements. Which steps should be implemented to have a right to recognize some kind of protectable trade secret. You know this criteria. Information should be not in public available. It should be created without violation of third party. But what is the next part? Only creation of trade secret not enough to go to investment deal. Next stage, you should put this trade secrets as intangible assets to your balance sheet. But believe me, almost no one from the accounting team they know how to do it. Because they're not enough classified to give official opinion. In what kind of trade secrets? There are more than 200 types. Trade secret, know-how, work for hire, how to classify, not existing. Because also this trade secret not belong to the state monopoly. It should be created internally by the companies. But to create this, you should have such high qualified expert patent attorneys like you know the biggest companies who can provide. So on small medium enterprises, this task is not possible to execute. This is sorry, I'm talking about the problem challenging because I'm from my open heart just to share this because we are all from one industry, and we will start thinking together. So because I'm considering IIPLA, I'm very big thanks to the IIPLA that you spend so many efforts to collect from all around the world these people. But I think if we will together unite and as a community to do something useful for our clients, then maybe government will listen. Especially in UAE. We have very quite successful experience in UAE changing the law. They have regulated laboratory in every Emirati judicial department affairs. We share experience and they can change law very flexible. I'm very happy to be in UAE and thankful to the countries who create such opportunity. So this one, I'm putting my pain, how we're trying to solve, maybe we can share experience how you solving this one, and then we can bring some benefits, some practical benefits to the business. Not only share experience between us, because we know every from you is very qualified, but when we change, we can create something for the community also. Thanks so much.
Hi, good morning. Actually, I had something if I could. I have actually nothing so unknown to any one of you. These are the general things that question in a physics paper that whether there is a relation between speed and velocity. And the question carried 20 marks. So one student replied, the answer was no. So the teacher said that just apply your common sense that if a question carries 20 marks and you are replying no, so that will not help because when the answer must be yes, and then you have to describe the relation between the two things, the two items, the speed and velocity. Similarly here, obviously, the answer is not when we talk about IP in today's business landscape, so the relation between IP and business, the answer is obviously yes. Now anyone during the current times when we are doing business, so the IP since the modern times when we are using when we are entering into any business activity, so we always find IP along with the business. So now these things which I just wanted to elaborate briefly is that when we are having the business to be recognized by our customers, by consumers, then there are some different types of IPs that we are which we are representing, and like the trademarks which will provide the distinction between.
I suggest you speak about it because some of the audience can't see the screen.
That's why I'm just. I don't know whether it's there on the.
Yeah, we have to
Sorry about that.
So the point is that when we are, obviously the main point is that when any person who is doing the business, his main goal is to get the money, and when we want to do that, so we now in the modern age we always face issues which when they don't let you go straight peacefully. They will always, you will, as soon as you are a little successful in your business, you will see the people around who want to make use of the goodwill that you have achieved. So in order to do the business peacefully, obviously is the intellectual property that comes into the scene, and then with the different types of IPs that we are know now, that include the trademarks, patents, all these, which obviously, as I said, is nothing unknown to any of my friends here. So the trademarks that will make our business known to the community, to the consumers. Similarly, when you enter into some sort of industrial operation, so as soon as you have something which you are creating, which has some industrial applicability, which has some novel in its side, so then you apply for a patent, and when you get a patent granted, it means then all the consumers recognize that now you have something which will push them to invest in your industrial activity. So with these IPs that we are having, which we come across every day, trademarks, patents, copyrights, industrial designs, and we are having issues which is not only which will obviously help the business people to achieve their goal, to have a successful business, and not only to have a successful business, but to have a successful business peacefully without having issues which we come across. So that is why when when uh, uh, when a client comes to us, approaches us, that we are having issues, mostly now when we see the trademarks, many people who come to us to register a trademark, they only come when they face some issue, when they will see that they look, I have this product and my other competitor is now copying my brand. So that then at that time they come to us. So obviously these issues now are not unknown, that the infringements in the market are so widely spread that you think of creating a peaceful environment for the business people to, with all the possible IP types of IP protection that you can provide. So that is why to cover different aspects of the business around, you obviously do the registration for the trademarks, or if there is an applicability, and also especially along with the trademarks now, simultaneously many of the clients require that you protect their product as an industrial design, because it will carry some specific type of design which may not be accepted by the trademark authority to be acceptable as a trademark. But we still require a protection for that product. So that is why we are always forced to secure the protection of different kinds through different types of IPs. So these obviously, as I have shown here, they are and they don't require that some sort of introduction is provided, or we can discuss. Everyone knows all the IP types, but only I just wanted to highlight that when we are dealing with a client, so as we require that the client, first we have to identify the issue that the client is facing, and then accordingly we are advising whether your problem can be addressed with what type of protection, and then obviously that will create the basis to go for the next step when we are enforcing the IP rights. So as my colleague was talking about copyright, or the problem that we face is that now a lot of countries now don't provide the protection of a copyright through a registration system. So when you create a copyright, then we obviously know that when a work is created, so automatically it is you get the IP rights in that copyright. But the problem is that when you go to the court or an enforcement authority, that look, I have this copyright, so then the problem that we face is that how to establish your right. Because like if you have a trademark registration certificate, you can easily show to an administrative authority, to the court, that I have this trademark, this is the filing date, since that time I have the trademark. But for a copyright, when we create a copyright, but we don't have the registration, so then establishing your rights in the copyright when there are other people claiming also in that work the right, so then that becomes a little difficult. So when we are advising the clients to register a trademark or a design or create a copyright, we always need to advise additionally that look, when you are using your intellectual property, so let us try to establish your right, because every intellectual property will not be so easily established through a certificate. So let us start establishing your rights through your use. Like when you are using a trademark and you are selling the goods, so the invoice that you are creating provide the description of the goods and also the quantity or the price, etc. But a lot of times what we face is that when the client comes to us with a lot of evidence to establish the use, that this is the evidence of use, when you start reviewing it, so you see everything in the invoice except the trademark. You don't see the invoice carries the trademark. It is carrying the description of the goods and everything. So he's saying, look, I am using this for so long. But when you present it to the authority, it does not carry any acceptability. That's why we also need to advise the client that when you are generating an invoice, so always make sure that your brand is stated in the invoice properly, and if it carries some logo or something, it is better also, like letterhead, you can create something that can be easily established with the authority that you enjoy the right in that particular intellectual property. This is the point that you always, almost wherever it is possible, you can try to create some sort of evidence that can be accepted by the court of law, which is maintainable in the court, and that is the point. So then, therefore, to create such an environment, there are different types of sectors that collectively or as a team can join together and create an environment for the business to establish its rights and to enforce its rights against any unauthorized use, against any infringement. And for doing that now, as we know that each country provides some sort of litigation and some protection to the intellectual property, but as long as now we are entering into more and more cooperation between different world communities, so there are different types of registration systems that can provide us wider protection with much less budget and with much less exercise as we do in each individual country. So that is how now a lot of clients who are who see that there is some protection available, like through Madrid system or in the European Union, so those obviously will love to have that. There are different aspects obviously, which there are some pros and cons in entering into any type of such registration system, but by and large these are creating much easier way to secure your right and to enforce your right. There is one thing that when we say that we have to create some environment where the people can easily and peacefully conduct their business, then we also approach the authorities to create such an environment, to help creating such an environment where a peaceful business activity is possible. And in a country like United Arab Emirates, we can see that the authorities are quite vigilant and in enforcing the IP rights, and whenever they see that there is any unauthorized activity going on and you approach them with a proper maintainable evidence to establish that you are the right holder and I am being unfairly treated by my competitors, so they will always come forward to help you. And this is what we see in the administrative authorities, whether it is RDED or whether it is customs or whether even if you go to the litigation in the different emirates. So everywhere you feel such involvement is there. But there are, at the same time, we see that the governments are trying to make the procedures simpler and more helpful. Like, for example, here we see that when the client knows that you are okay, this is a registration system which is easy, I will just provide you the information and then you go ahead for filing. They feel that when you have the documentation, so there are some legalization requirements that obviously many of the clients may change their mind when they see such a huge legalization cost. So that also with the whether it is the regulations made by the government or by the concerned departments, they also, we see that gradually many, for example, now many of the countries in the region like Oman or Bahrain, they have entered into the this posting convention. So with this such types of steps, which also will be quite helpful in achieving environment where seeking the IP protection is easier. So such, when we are discussing among us different aspects that we come across, so these things also we need to summarize and take our authorities into confidence that when we create, obviously there is a revenue which the government has through the legalization fees, but on the other hand, when the legalization becomes easier, then it will help more people to enter into this regime and have more protection. So the revenue that the government gets and also the business that get in the form of investment and in the form of healthy business activity, that will be helpful when the regulations are friendly with the procedures that we require to protect our intellectual property rights. And obviously, this is the point where we see the need that all the sectors, whether it is the government authority, administrative authority, courts, or the IP professionals, and then we have to create an environment where the businesses, the people who are doing the business, they learn how important it is to secure their intellectual property rights, which they do have, but they don't see the importance of securing it through some procedure. So that is the point that where we now provide to help the client to understand and also to educate the community to enter into create such an environment where everyone understands the importance of getting the registration through it. Thank you very much.
I'll just conclude a little bit. One of the points that I saw from my colleagues here, thank you so much. I would say that at this point in time, there is a lot of uncertainty. We have the traditional IP regime still available. All those aspects and all those tools are available to us. The law is established with respect to different types of intellectual property. However, I think as we move into more advanced technologies, the current applicable standards will have to change, and they are changing. So first, I think what Mr. Mubashir said is very relevant in the here and now. Many businesses, far more businesses than not, are still going to require traditional IP protection, and you have to be practitioners in that area. I think where the watch-outs are going to be are in the new areas where we don't as yet know what the implications are. We don't really know how to enforce, because it's going to require educating not only the stakeholders but also the judges with respect to what you actually own, how does it actually work, why do you own it, what is the situation, what would be the facts when something that's been created by machine actually is then still in the view of the judge will have to be owned by a human actor somewhere in the chain. Well, what if it's truly difficult to prove that? So there are going to be lots of elements that I think we haven't seen before, but the starting position in all cases is going to be the law that we have at our disposal at the moment. And I think when in doubt, if you all agree, contracts do have to still protect you. They are your main fail-safe, because still you would hope that a judge does understand, you know, what the parties are trying to agree with respect to ownership or infringement or risk or warranty or what have you. So I think it's going to be still very important to use the traditional elements as much as possible and keep speaking to policymakers, keep trying to push back with respect to the bigger tech companies to make them understand what the community engaging with their products is actually needs or might be at risk for, etc. So I think contracts, I think you made a point about the human programmer element in all of this, especially in content creation. So I think employment contracts have to play a huge role as well. You have to really understand who owns something that they're creating, which is going into a massive machine for something else, yet the ownership is very relevant to prove your ownership of that product. I think the whole space of contracts to me at this point in time is all the more important to make sure that you define as much as possible what you're trying to protect, but also really be there in the community trying to educate as you go along. Because ultimately somebody who may not understand what you own or what you have and how it's created will be actually passing judgment on your rights and your investment. So that would be sort of, in conclusion from my side, that I think contracts are all important. You can't do away with traditional IP. You have to start there, always, and try to extrapolate. Try to educate your clients to involve you as early as possible in the process, and don't let any single policymaker go, if you see them in a corridor, to try to explain this point of view and what the needs are and what they're going to be. So thank you very much.
Thank you so much. So do we have any question from the audience end? Yes, here we go. We have two questions. Hold on.
First of all, thank you so much for this session. My name is Dr. Hamida from Maxim Mark Intellectual Property. First of all, I agree with Mr. Mubashir and my colleague regarding that some companies and some investors don't know the value of intangible assets regarding the intellectual property. And they come to us as IP agents or IP attorneys when they face a problem. So I think the most important task in this procedure is how to raise awareness between the companies, SMEs, and the new startups about the value of intellectual property, how to protect their trademarks or copyrights or whatever in advance, before facing a problem. And as Mr. Mubashir said, in some countries, copyrights are protected when they are created. But coming to infringements or filing any legal action against any infringer, most of the government departments don't consider any of these things. They need a registration certificate or grant certificate or any official document proving that you are the owner of the right. Otherwise, they cannot take any further steps regarding how to take action or something like this. So now the most important thing is to raise awareness between the society in general, between the new startups, new SMEs, and the importance of intangible assets, how to make use of that. This is very important. Thank you so much.
Yes, if I can, small addition. Yes, this is a very challenging task to prove properly the establishment credentials, as you also mentioned. And we spent 1 year to find a proper corporate office who giving certificates, and these certificates recognized in the court, recognized in the Google, in the Apple. Maybe if you're interested, I can share our experience. So we have selected 20 to the biggest corporate office: United States, UK, China, Russia, India, European Union, and we filed. And when we filed the application, I have my friend in Uzbekistan. He is owner of a big farm. He has about 2,000 sheep. And I put his name Tursunbek, as an author and right holder. And when we filed to UK Shakespeare Award, we filed to India Mahatma Gandhi, to United States we filed the Lincoln, Abraham Lincoln, and the all office registered his name, all these parts of the work. You know? It was quite funny story. In Russia we applied the Pushkin, the most famous, so it means no one checked. It was by notification. And his farm in Uzbekistan, he has a big wall with all gold stamp certificate, all corporate office, that he has owned all this work. And only when we applied in European corporate office Interlock in Germany, and we put the Goethe, maybe from Germany, they know the Goethe is the most famous writer in Germany, they rejected to us. They said, sorry guys, we conduct the applicant, we conduct the search, it's not your work, they don't understand, they conduct the search. Only Germany, one corporate office, conduct the search and give us refusal. Then it's okay, let's start work with this. And when we receive the certificate, we understand it's not big corporate office, it's not like United States, but they're quite good doing their job. Maybe it's Germany is in mentally to do something with big quality. And there is a certificate that we're using. So maybe it will be useful for you not to spend 1 year like me. Just use the Interlock corporate office in Germany, they provide the proper protection. And second issue was evaluation. You know what is the final thing? That to make initial recognition in balance sheet, no need to go to appraiser. No need. There are cost-based evaluation. So whatever cost you have spent for marketing, for the salary, for the creation, you have directly right to record these expenses not as a cost, but as an investment in intangible assets. And for such kind of accounting transaction, no need to receive report for external licensed appraiser. So initial recognition could be done, but this awareness. Because owners of the business they don't know. For accounting, to have $1 intangible asset nightmare. He don't know how to record, how to calculate useful life of those assets. What kind of assets? They know on the website, but website is not IP. You know, website consists of the copyright or the other things. It should be split in proper IP types. No one from accounting knows how to do it. So if you will start, I fully support you to start informing at least business owners how you're spending so many money. So one of my clients, we are working here, just it's not for the advertising purpose, but as an experience. When we explain that they can capitalize this asset, now this company value is 240 billion United States dollars. It's IHC Holding, biggest company, is our client. We provide proper explanation how they can capitalize the cost, and then make the revalue of the second step. Because you will spend the money will be withdrawn from your balance, but you have right as a business owner how to record. If you record as an expense, you will lose the money. If you record as an investment, just free of charge accounting transaction. But no need to pay it, 1 million won, but they should be qualified to do it. And if the business owner will ask accountant, I need you should do this one, force them, they will resist. Up to last drop of the blood, accounting team, audit team, legal team, they will resist. Because they don't want to have IP intangible assets just spending money. Well, no one else will. But if you then can force. Why Big 20, Microsoft, IBM so big? Because they're forcing accounting to do what needs the business owner. But what is not comfortable condition for this one. So for valuation, at least if they start recognition, something appears. And then make a remark. We are not recommending to record intangible assets directly based on valuation report. It's some like suspicious. One day 10 million appears. It's balanced. Believe me, all the starting from bank up to they start putting so many questions. So then better not to do. 2 steps: recognition cost base and then revaluation. This is our experience, which is working. Just small answer for the question. Thank you.
Hey there.
Can time stamping be one way of protecting it? Time stamping.
What is the problem with time stamping? With time stamping, you don't know the KYC of the author. You don't know credential of the right holder. You don't know the type of the IP. Because, so we have registered almost 2 million works. 2 million within 28 years. It's enough. So the problem is that with time stamping you cannot prove. You know, World Intellectual Property Organization, WIPO,
Yes.
they tried to create a service for token registration. It was only 6 months after they closed this one. Why? Because all Chinese guys, they start registered all United States mobile application startups, do this automatically, and filing the cases in the Google, in the police, in the CID, in the VARA. Oh, I have certificate for WIPO, which prove my right for source code, this validated. Start blocking, remove. It was crazy task. The only solution for WIPO was to start verification process to check for uniqueness. How they can check uniqueness of source code. It's so challenging task, you know. We found the way how to do it. There are some special repository, GitHub, but it's very expensive work. No one will do it. All corporate officers are using automatic by notification. Verification of source code, it's complicated. We know how to do it, but our service is not so cheap. If you do it, you can do it. This is the problem with timestamping. You cannot use this. Only the date, date of priority you can use. Nothing, but for law enforcement, for litigation policy, not enough. They don't understand at all what is timestamping. You can share it. We try to talk with police, Dubai police. They send WIP registration. What is it? It's hashtag of the token. Believe me, for police expenses, based on hashtag of the token, you're asking to open criminal case. It's not possible. It's a very challenging task. And one more thing for the virtual assets. We find a solution how we can legalize the virtual assets. You know, if you take the IP rights, put in the IP portfolio, and then register as a one My Life Hack. Consolidated compose the copyright work, one. Start with the brand, source code, design interface, and then this one work we can split to IP shares and start selling the IP shares using token as an encryption tool, not subject of the deal. Because if you will sell token directly by American CS Commission, Security Exchange Commission, you will recognize as unregistered security, you will block it. But if you will sell the IP shares like property, using token as encryption tool, this is allowed. And now we helped one of the biggest metaverse, Sidus Metaverse, 250 million valuation, they have 20 planes. And we support them to start the tokens as IP shares. It's very interesting. And 2-3 years ago, we registered first NFT as IP. How we registered? Because NFT consists of hashtag, this part of source code. It's a very complicated task. Design, it could be as a design, as copyright design. Also special subdomain name. This derives your product. If you combine 3 in 1, it's a composite copyright work, we protect it, valid, and sell to investor. So IP is very flexible. But the problem is that everyone should find his way how to complicate, how to arrange everything to provide for the business, because they need the solutions. But the government is sleeping for them, so we should do for ourselves.
I think ultimately it is about value. You know, IP, I think the point here that's been really should be broadcast and heard by all of us is that there is value in IP. There's value in owning these rights. And if you can look at, I mean, these are billions of dollars of value. And to a startup, it could be the only asset that they have, right? And they've poured all their effort, they've raised money on the back of it. So I think at the end of the day, these validation exercises, these are very complex cases, but the fundamentals are still the same. You're still having to follow the principles of basic IP. But I think the sky is the limit, really. And I think as technology advances, it's going to be even more interesting. But validation, verification, steps that you have to take, you know, from a principal level, that's important. But there's real value in IP, and I think clients have to hear that, you know, all the time and upfront. And how you do it is
just one last comment. Real value, this economic definition, it's not legal.
Yes.
Real is not. So there are, as per our experience, please learn to use at least 8 valuation methods. Because there are 8 values always existing. Market value, mortgage value, balance value, and investment value. So when talking about the value, it's 8. Which kind? Real value is what in generic. Yes, it's good, but for legally, when you go to legal, to accounting, to Big Four, they will ask what exactly kind of value. Based on our experience, the best option to calculate 8 value and take something mixed, like which combined, like integrated value based on this valuation, 8 valuation methods. This is our experience for the value, then maybe we can help. Because if you ask any startup how much you cost, he will say, my price 1 billion.
They won't be able to.
If you go to the bank and ask, okay, I want to bring to you this startup, how much you want to give money? Okay, $1.
Yeah.
Or maybe $100 for copyright registration. So from 100 to a billion. So it's very complicated. So our experience, just 8 value, go, make it integrated. This somehow will help you at least to have ground for starting negotiation. Definitely no one from investor or the company will be agree with the initial value you put. No one. They will always push down. But it depends. You will push down from 1 million or push down from 100,000. This is our practical experience for more than 7,000 valuations that we have.
Yeah, absolutely.
We have one more question, please.
Hi, Tim Londergan. I'm from Tangibly. We make software for trade secret management. So a lot of this discussion is near and dear to my heart. So a couple questions. One is on the accounting. my understanding is in the U.S. Under GAAP accounting rules, that it's very difficult to just sort of throw something on the balance sheet that is an intangible asset. Whereas with IFRS accounting, there's actually a mechanism to take something intangible and make it tangible. Do you have any experience in GAAP accounting and doing this? It's something that has been talked about in the U.S. like here and there for the last few years, but no real kind of movement. But do you have any GAAP experience?
Yes, of course. We have lots of clients in the United States. So what we have done? For us, much comfortable international accounting standard number 38, yes, valuation of tangible assets. For us, it's more comfortable because there are clear definitions, there are 3 criteria to be recognized. Yes, that it should be not physical, it should bring some benefits, and companies should manage it. It's much clearer. And we prefer to work. But when clients come to us from the United States, what is the biggest problem from the United States? You should properly separate which assets could be considered, which is not directly related to goodwill, and as a separate IP portfolio. This is the most challenging task. By American standard, almost not possible to capitalize the salary, because they're considering salary part of the company, and you will benefit when you will sell this company, and additional goodwill will cover the cost of the salary. This is a challenging task. So how are we solving this one? Very, very easy. We're trying to explain the base of this salary. If some employee was involved in the creation of the brand, as a software and other things, so it means that this part of salary should be attached to the research and creation part of the external service provider, because there are 2 parts, to the creation and to the utilize to the operation. We're trying to take this part of salary, to the cost, and attach to external created work. Only this way, because as I said, United States is a very old system. But no one from American entrepreneur will do any step without advice from accounting and the legal. This culture of the United States. In UAE, we are mostly business oriented. If there is some chefs, local, some will ask, I need this one, accountants will find out how to do it based on the task which he received from the top. United States, no. Without legal opinion, without account, you can do nothing. This is the reason why we're not so active in the United States. It's a little old. But my advice, just to try to take, because expenses is a very important part. And Microsoft, Apple, they're all doing this one. But directly is almost not possible. This is how it's short.
That's very helpful. Then the other thing was your comments on large language models and all things relating to risk there. Just couldn't agree more and emphasize that enough. And I think one of the things you pointed to is some standards in and around intangible assets. And so what was that standard again? You mentioned it.
You mean for valuation?
Yeah.
Yeah, 210 standard.
210.
Valuation of intangible assets. This standard was approved by International Valuation Standard Council. This council is located in UK and accredited by United Nations to create a standard for all valuation proposals, not only tangible, even intangibles.
So one of the things we've started talking about and formed a working group of sort of grassroots. So it's law firms, companies, different kinds of practitioners. But what is the standard for trade secret management or confidential information management? So if you look to like SOC 2 compliance, for InfoSec, I think if we see each other again in a few years, we may have a SOC 2 like standard for confidential info, and I think a lot of it does come out of this large language model problem, which the only solution right now seems to be like shut it down, right? And so how you handle that data. It's kind of a big mess right now. So if anybody's interested in standards around this stuff, love to talk about it over the next couple of days.
So I was one of the meetings was the World Intellectual Property Organization, WIPO. They clearly mentioned they don't care about trade secret and confidential information. Clearly, and among the 26 agreements under which administrated by WIPO, not existing nothing but I was shocked. How? Today the trade secret customer lists the main assets. Intangible, why not consider? Sorry, Dr. Sanjay, we are not receiving any fees from this incorporated party. We will not touch this one. I was shocked, really. Right now, when we are trying to protect trade secret, On the local level, it's clearly mentioned about corporate companies law, others, but on the national level, we found the TRIPS agreement under World Trade Organization, where it's mentioned. If you want, I can share with you. So now it's stupid. So main company organization of the IP don't want to make with main asset of IP, but it's the reality. So we combine two parts. We take the local laws and World Trade Organization TRIPS agreement, where some part of confidentiality is described, but it's also mess. They put reg secret where know-how is just one paragraph. That's it. This is a challenge task. You mentioned the biggest problem, but we found a way how to do it. Thank you for nice question.
Thank you so much. So we can catch up later if anybody have question. Well, you guys did a wonderful job. It's an amazing session. So now I request our moderator, Una Farid, to honor our panelists with the mementos. Thank you so much. Please be on the stage so that we can have a panel group photo.